Welcome, everyone. Welcome to our annual Robert W. Kastenmeier lecture. And I know that we are delighted this year to have a number of people from a variety of campus departments outside the law school. Welcome to the law school family, and we hope that you will like what you see and come back frequently. This lecture series was endowed to honor one of the law school's heroes. Robert W. Kastenmeier was a 1952 graduate of the law school. It didn't take him long to get elected. I hope that's somewhat attributable to his law school experience, and he represented this district in the United States Congress from 1958 to 1990. During the course of that time, Congressman Kastenmeier was responsible for a number of major legislative achievements, and so this lecture series is geared toward programs that really focus upon some of the areas that were near and dear to Bob's heart and were a major focus of his legislative work, including corrections, civil liberties, the judiciary, and our subject for today, intellectual property. So, without any further ado, let me introduce Robert Kastenmeier.
Thank you, Dean Davis, for that kind introduction and a reminder of what this series is really all about. This is the 10th of our programs since 1992. Remember, we started out with the Chief Justice himself, who came here. We're delighted to have him talk about the courts way back in 1992. I'd like to also take this opportunity to thank a number of people. Dean Davis, certainly Professor Cartensen, who is the major role player in putting it together. John Kidwell, who has always helped in the past and had that responsibility in years before. Teresa Doherty of the law school, who's worked so well. And even our people from Washington, Bill Kaplan is here, and Mike Remington. They too their work is appreciated in this and all the other programs we've had in the past. Some have asked whether I'm responsible for the title of the lecture, and the answer is no, I am not. As a matter of fact, the only thing I can say about it is it rings to the far distant past. Many years ago, I think I did hear that refrain from some of my creditors. I've forgotten the balance of Robert Kastenmeier. But I am glad that Professor Lessig didn't try to bring in fair and balanced. He might have run into a problem with Mr. Murdoch and the Channel 5 News. In any event, our speaker is one of my heroes, one of the people I do admire, and whose approach I largely embrace to the extent I understand it. But it is not my role to introduce him. It is really a different person, also a hero of mine, one probably well known to many of you, Dick Cates. Dick and I have this in common. We started in politics in the 1950s. Dick very successfully, but after a year or so, after a term in the legislature, he took a different path. He went back to his first love, the law. And there he has been for 50 years, always willing to be of public service. I can report, as you perhaps know, we called on him to come to Washington for the impeachment process of Richard Nixon. He was our first counselor. He was the one who put the case together, who talked individually and collectively to the members of the Judiciary Committee over the first months of our endeavor. And to him, I think much of our success, of the outcome, if you can consider impeachment a success, is attributable to Dick Cates. It is probably ironic, Dick was not chosen by Richard Nixon on his enemies list, but I was. Dick also came back in another 12 or 14 years to help us with the first impeachment of a federal judge in 50 years. But that was typical of his service, and I cannot describe his service in Wisconsin. The fact he was a role model for so many and taught so many young lawyers and law students over the years. I know he has served in many ways his community and his state as well as his federal government. In any event, it is with pride that I present to you my very good friend, Dick Cates.
It looks like I'm old in the way I walk, but I got a hip replacement in August. So now I'm 50 years old. You know, he waxed eloquent with respect to me, and I feel humbled, really, by the fellow who's going to talk to you. This young man, he's a relative. He's my wife's nephew. So I've been acquainted. You have in your book some of his CV, whatever the document is, what you give somebody to show you've done something. Pardon me. I was in the Marine Corps and I could talk to 200 folks without this damn thing. But I want to talk about how this man developed. I want people who are in law school to hear the way a person like this, really all by himself, made it to the prominence that he has. When he was a little tyke, he liked to sing and he liked music, and his family decided that he could become one of the boys' choir out of Columbus. He spent 4 years there, and they went all over the country, and they went all over overseas. This young man was identified by professors, if that's what they were called at that school. One remark was that he essentially had the ability to learn by himself. And the other one was that I see in this young man a great man. A young boy, I see a great man. he essentially was a straight A student there. He learned to work in that environment. And when he came home, he stayed connected with that. He was a valedictorian in his high school, but chose to go to Korea to tutor some of that boy choir. That essentially, I think that experience caused this young man to have an awful lot of time to think about himself, think about his values, and what he wanted in life. He went to the University of Pennsylvania, and he got an MA in economics, and he got a Bachelor of Science in management. He was graduated magna cum laude. But he took a philosophy course in his senior year. And he became, because he wanted to be his own man right from the beginning, he started to realize that he had to learn who he was and what his values were and what kind of life he would choose to live. And so he decided to go to Trinity College at Cambridge University. And he studied philosophy for 3 years. And that's what he thought about. What were his values? That's what the subject is. It forces you to look at what you're doing and what you're not doing, what the other person is doing. Forces you to listen to what other people have to say. It forces you to think rationally so that no matter what your position is, you can make it understood. And he came back, and he was all done business, and he was all done economics. He then chose to be a lawyer. And he chose to be a lawyer, essentially, because if you do law right, you can have a tremendously satisfying life. Because in our nation, which is dedicated to freedom and human dignity, it's law which is the tool that accomplishes that. And all of a sudden, this human being was transformed into a compassionate, dedicated, hardworking human being that he could do as a lawyer. I was fortunate enough to be in Chicago when he was, when he was in Chicago as a clerk for Justice Posner. He was the Chief Justice of the Seventh Circuit. And Larry would come up and we would talk. And I could see that he wanted to live free. He wanted to stand for the principles that he believed in. He wanted to know what kind of a lawyer could do that. The problem was that it was very difficult to do that at that point in time in the kind of practice that was available to me when I started. By this time, he had already seen what a big law firm was. And you weren't going to be independent. You weren't going to be free. You wouldn't have the slightest idea what your responsibilities in terms of to yourself were. So he struck the practice of law. He said, I saw it, I don't want it. He looked at what I did. He would have loved to have done what I did. But the times were different now. People were, the firms were larger and larger and larger. They all had their own trial lawyer. They essentially all specialized. Well, specialization may make money, and in some instances it can be satisfying. But it really isn't as wonderful as what this man wanted. He wanted to stand on his own feet and fight for the things that he believed in. And so, in that conversation, we talked about the pros and cons of government lawyering. Government lawyering can be very satisfying, but it also has, oftentimes, political nonsense. So he decided on, he'd had the offer from Chicago, and he took it. And from then on, this man has built a knowledge. He's a constitutional lawyer. He has gone all over the world. He was telling me how through Russia, when he went, he could see the ridiculous nature of the government from the top. You needed the people to make a contribution to what your nation was so that it wouldn't die. The leaders wouldn't kill the ground. They wouldn't stifle the people. And essentially, what he did is he became a lawyer for, he was a professor, but essentially he became a lawyer so that the people in our nation can live free. And those are the subjects he's worked on. I have read his books. I can't say I understand them, but I see a human being who is talking about both sides of any issue. I also have read his briefs to the Supreme Court, and when he was asked for a brief by Judge Jackson, amicus, he wrote a brief, and it was wonderful. Years ago, when we went to this law school, it was hammered on us what a brief to a court would look like. All sorts of rules. Today, I don't know very few people who follow those. But when you looked at these briefs, you knew a lawyer, a really good lawyer, had presented them. And they were rational. I saw that on television. Periodically, he would be involved in a matter where there'd be a legal issue discussed. And the man essentially not only always made sense, but he made it in a way that you could understand, and in a way that you had to respect. And frankly, I think, taking a line from the movie with Newman and the other guy, when they're being followed by this Indian, and they're in a game, and one of them turns to the other and says, "Who is that guy?" Well, that's what I believe people, when they hear this young man talk, come away with. How the hell did he get there? How is he so good? How is he so thoughtful? Well, he was because he wanted to be good, and he paid the price. And I'm very humbled, and I'm very happy that I was able to talk about him and tell you about him. Thank you.
Dick, and all of you, thank you very much. It's humbling for me in particular, so I'm going to stop talking about me now. Our Constitution gives Congress the power to set copyrights. Article 1, Section 8, Clause 8 gives Congress the power to promote the progress of science by securing for limited times exclusive right to authors for their writings. In 1970, Congressman Kastenmeier said, "This is the only place in our Constitution where the word progress is used. And it must mean something by using the term it does. It's also the only place in our Constitution where the word limited times is used. It too must mean something. The framers of our Constitution, when they set up the first copyright statute, said something about what it meant. They set a copyright statute that granted authors a term of 14 years for their work, which if they lived could be renewed to be a maximum of 28 years. But that term, through the term of our history, has changed. In 1831, for the first time in the first 100 years of our republic, the term was extended to 42 years. And then in the next 50 years of our republic, it was extended once again to 56 years in 1909. But then beginning in 1962, look, no hands, the term began to be extended. In fact, it was extended 11 times for existing copyrights until the 1998 Sonny Bono Copyright Term Extension Act, otherwise known as the Mickey Mouse Protection Act, extended the term for 20 years. This was an extension for both subsisting and future copyrights, and under the existing structure, if an author created in the way someone like Irving Berlin created, it could create a term which is up to 140 years long. Now that change in the term of copyright is consistent with other changes that have happened in the context of intellectual property legislation, and consistent with some unintended consequences that have happened in the context of intellectual property legislation. If we think about a distinction first between commercial uses of creative work and non-commercial uses of creative work, and a distinction between the act of publishing a particular creative work or transforming a particular creative work, then in a very law professor way, we could put these together in this matrix and get a map of how Congress has changed copyrights regulation. In 1800, copyright law regulated just this square. Copyright law regulated just the commercial publication of maps, charts, and books. It left the act of transforming those works by translating or abridging or setting to a dramatic form free from regulation. It set free the non-commercial transformation of creative works, people around a corner talking about what a story meant or extending a story or changing it in the way that they wanted. And obviously, it left free non-commercial publication because the law required a copyright owner had to signal through a mark and a registration that they wanted the protection of the law, and over 95% of work created in 1800 never took advantage of that protection, meaning 95% of work was free for others to republish however they wanted, free of the regulation of the law. Now, in the first 100 years of our republic, this map changes slightly. This is the only change. The law extends to what lawyers call derivative works, giving the copyright owner the power to control translation or abridgments, but still leaving free non-commercial uses of creative work. And then in 1909, totally as an accident, the law changes from publication to copying. The term copy was a technical term that would be used with works of art, not with books or maps or charts. But the word copy became the focus of the law's regulation. And this meant that the law regulated as broadly as machines enabled copying. It was regulating, in the words of one author, men with machines. But of course it didn't matter, because in 1909 not many men had machines. They were expensive and big, and it regulated still just a small space of commercial life. And then, as technology changed, the scope of the regulation changes. As there are more machines, there's more regulation. And as machines like Xerox machines become more common, the line between commercial and non-commercial uses of a copyrighted work becomes more blurry. And then there is an extraordinary change, produced by a technology which has as its core the idea of copy. This is the technology of the internet, which when it swept into copyright's field, undermined a fundamental distinction between the laws regulating commercial activity and the laws regulating non-commercial activity. Technically, all of it was within the reach of copyright's regulation. So let's take a very practical example. Imagine a book before the internet. And here are all the possible uses of a book before the internet. Most of these uses are unregulated by the law. Not fair uses, but unregulated uses. So if you read a book, you don't produce a copy. It is an unregulated use of the book. If you give a book, you don't produce a copy. It's an unregulated use of the book. If you sell the book, you don't produce a copy. It's an unregulated use of the book. In fact, the statute explicitly says it must be an unregulated use of the book. If you sleep on the book, you don't produce a copy. It's an unregulated use of the book. These are uses which the law has nothing to do with. And then at the core of the possible uses of this book are a set of uses which are properly regulated by copyright law. To publish the book would be a use that is properly regulated by copyright law, and through hundreds of years of judicial interpretation, finally ratified in the 1976 statute that Congressman Kastenmeier helped craft, there's a thin sliver of fair uses of a copyrighted work, uses that would otherwise be regulated by the law, but which the law says should remain free. Enter the internet, where, here's the only technical point I will make today, every act is a copy. It's the very nature of a digital network, that every act you perform on that digital network produces a copy. And the consequence of this technical fact is that this space of unregulated activity is now presumptively regulated. The law presumptively extends into a space which before was balanced between regulated and unregulated uses. Now, this is not necessarily bad. My point is not that copyright is necessarily bad. But as with all regulations, especially regulations of speech, it should drive us to ask the question, does this particular regulation produce more benefit than burden? Now, I think, obviously, in some of these spaces, it does produce more benefit than burden. For example, in the context of commercial publication, the regulation of copyright law does clearly produce incentives that otherwise would not exist, and therefore those incentives help produce creative work that otherwise would not be produced. Footnote, a justice of the Supreme Court got tenure at Harvard by arguing that even in this particular context, copyright law was unnecessary, but that was Harvard, so we don't have to think much about that particular point here. Let's take it for granted that copyright law produces more creative work through its restrictions than it burdens. And in the context of transformative work, at least transformative work in the 19th and 20th century, there too, we could argue convincingly, I think, that copyright law produces more incentives than burdens. It therefore induces more creativity than it restricts. But as we move around this space, it should become more and more obvious that the good that copyright law is doing is outweighed by the restrictions copyright law imposes on activity that it has no justification to control. So fan fiction sites where people get together and talk about what Kirk and Spock really do behind closed doors, these are creative acts of people totally independent of a commercial marketplace, but they find themselves threatened with legal regulation when they make those acts appear in the context of the internet. And at least some non-commercial copying, you might be convinced that Kazaa is a bad thing, so we can split this up a bit, at least some non-commercial copying should clearly be without the reach of copyright regulation, especially given the way in which these new technologies enable people to create. That change should force us to reconsider something of these balances. So I want to think about two dimensions that we should be reconsidering. First, the dimension of term. In 1973, before Congress passed the 76 Act, which radically changed the way in which the term of copyright was set, the average term of copyrighted works was 32.2 years. The average term was less than the maximum term because the term was given in two parts, 28 years and 28 years. And 85% of copyright owners never took advantage of the second term. So the average of those who actually take protection is just 32 years. But in the 76 Act, Congress eliminated the renewal requirement and the registration requirement. So today the average term is the maximum term, which for corporate works is 95 years, which means in just 30 years, the term has tripled. Now many people say, so what? What's the harm of a longer copyright term? And to get the sense of what the harm is, we have to put some numbers onto the facts. The term extension of the Sonny Bono Copyright Term Extension Act affected work that was first created in 1923. If you take the work that was created in 1923 to 1942, just 2% of that work has any continuing commercial value at all. This is the work of Disney, Gershwin, and Frost, work that is extremely valuable to the heirs and assignees of these creators, or the corporations that continue to hold power over these works. And it's these groups that were most responsible for the lobbying that led to the extension in 1998, the lobbying that would give them 20 more years of profit from this 2% of creative works. So the benefit to them is clear, and to most in Congress the benefit was clear because we were helping Disney and Gershwin and Frost, great people from our tradition, or at least the heirs of great people from our tradition. And we, of course, love these people, so why wouldn't we ever give them the benefit of a continued copyright term? But then what's the harm in giving Disney and Gershwin and Frost the benefit of 24 more years? Well, we lawyers should remember something fundamental about term in the context of copyright, which is obvious to people outside of the law, but not so obvious to those of us who live billing our hours hour by hour. The term is a binary switch. It says copyright is either on or off You're either subject to copyright if you're within the term, or you're free of copyright if you're outside of the term. Free, meaning the work is in the public domain. The public domain, meaning the work lives within a lawyer-free zone. Now that's extremely important, because a lawyer-free zone means that you can use or reuse the work without seeking the permission of someone else. Without seeking the permission, meaning hiring the resources to deploy in order to secure the permission. So let's think again about context of books. There's a guy, Brewster Kahle, the Presidio in San Francisco, who has built something called the Internet Archive. The Internet Archive is a copy of the Internet every month for the last 6 years. So you can go back to 1999 and search the Internet as of 1999 and see what the Internet looks like as of then. He's done this with billions of bots that have copied every page accessible on the Internet and archiving it in an extraordinary archive of machines. Brewster decided that it wasn't enough to build an archive of the Internet. He wanted to build an archive of knowledge. So he set out on the task of trying to take books that were out of print and digitizing them and making them available on the Internet for free. He wasn't interested in competing with the Gershwin-like estates where continuing royalties were being earned by the books. He was interested in making accessible works which the market had forgotten. So he went to his lawyers and he said, well, what would I have to do this? And his lawyers said to him, well, let's take just 1 year, 1930. In 1930, there were 10,057 books published. Today, 174 of those books are still in print. So we have a potential of 9,883 books that you might be able to digitize and make available on the Internet. But to do that, you have to make sure that you can digitize and make them available on the Internet, because they are presumptively under copyright's protection. So how do you go about making sure that they are free? Well, you need to trace the works. You need to trace the works to see whether they're under copyright, and if they are under copyright, you have to trace the current copyright owners. Well, a sensible person like Brewster thinks, well, there must be a list somewhere. Right? I mean, there has to be a list of copyright owners. A government-granted monopoly, you should be able to call up the office and say, who owns the copyright for a certain book? But as we know, there is no such list. To find the copyright owners, the current copyright owners, you essentially have to hire private investigators who can trace what happened to the copyright when grandma died and it passed through the estate down to the son. You have to find that out if you want to avoid extraordinarily severe penalties for infringing another person's copyright. And so projects like Brewster's stagnate because nobody can bear the burden of that extraordinary expense, an expense which is not defending the traditional purposes of copyright, which is to assure that an author has an incentive to produce a new work, an expense which, like a black hole of legal regulation, simply stops the flow of knowledge. We'll take a more tragic example. There's a studio in LA called Hal Roach Studios that owns the rights to these wonderful characters, Laurel and Hardy. Laurel and Hardy, of course, are creations which are the beneficiaries of Congress's repeated extension of copyright terms. So they've made, in the words of one of the owners here, millions of dollars because of Congress's extension of copyright term. But Hal Roach Studio opposes the extension, and in the brief they filed in the Supreme Court challenging the most recent extension, they made the argument for opposing it clear. They said, look, obviously, we make millions of dollars because of this extension. It's good for us. But unless you strike this extension down, Hal Roach Studios said, a whole generation of American culture will literally disappear. Why? Well, because this film that exists out there, that is not now commercially exploited, which is more than 90% of the film from the period 1923 to 1942, is film which nobody will digitize and restore because they're afraid of the potential copyright owners who might make claims against this film. Many of the films here are orphaned in the sense that there's no possible way to know who the real owners are, but if you restore the film and it turns out to be a great success, you can be sure the owner will appear and make the claim against you. So nobody restores film until it passes into the public domain, at least for the vast majority of this film. But the problem, Hal Roach Studios said, is that in 20 years, this film will have decayed because it's made on nitrate-based film, and nitrate-based film literally dissolves after a period of time. So by the time the Sonny Bono Copyright Term Act expires, assuming Congress does not extend it again, this work too will have expired. So these indiscriminate extensions, in both the context of the books and film, destroy opportunity for this creative work to be reused, for it to have a second life after the commercial life which initially led to its creation. And that indiscriminate extension then stifles the opportunity for creative work to be spread, and I think pretty unquestionably, at least I got 17 economists, including 5 Nobel Prize winners, including some of the craziest conservative Nobel Prize winners out there, to agree that this particular part of the extension clearly produces more burden than benefit to the copyright system. That's term. Now think about scope. If we have this as a map of what we think about copyright law so far, that some places it's clearly okay, and I think some cases it's clearly more burden than benefit, let's think about this place, the transformative space. Now, if your model is the model of Grisham, for example, John Grisham writes a novel, it gets turned into a movie, then the picture of copyright like this seems untroubling, because there's an author, he's creating work, it's easy for the director to contract with that author because there's just one author, and therefore it's easy to produce that transformative work. But what if this technology changes? Does this model of securing permissions make sense when the technology is different? Let's think of some examples. There's a guy, Christian Markley, who produced this extraordinary film called Telephones in 1995. Telephones literally has 500 snippets from 500 works made between 1920 and 1990. 500 snippets of 500 works from 500 films, each of which included something to do with the telephone. And it's an extraordinary story of the life of the telephone. It rings, someone picks it up, they try to understand who the other person is, they get into an argument, they hang up, they get angry because of that exchange. That's the story of the film, but it's constructed through these 500 different clips. Now imagine if Christian Markley respected copyright law, which he doesn't. He's an artist, why should he? Imagine if he respected copyright law and had to trace down each of those 500 copyright owners to get permission to include that snippet. That's what the law says he must do. But if he did that, of course, he would do nothing except spend his time on the telephone and not produce any art. So that's creative work. There's also lots of funny work that makes this point. Here's one of my favorite. Can you turn the volume up, please?
My love, there's only you in my life, the only thing that's right.
My first love, your every breath that I take, your every step I make.
I want to share all my love with you. No one else will do.
And your eyes, they tell me how much you care. Read my lips, take dictation.
Here's a technology which enables people to critique culture around them in a way that's extraordinarily powerful, much more powerful than simply words alone would allow, and then spread that critique broadly. Now, it's used creatively, it's used in a funny way. I can't resist my latest discovery here. Here's a totally unfair way, but here's a wonderful example of this type of...
Ladies and gentlemen, Rush Limbaugh.
They say that that I'm sleaze and elitist, you please? Everybody disagrees with my rap. I'm horrendous, I'm appalling. My ratings now are falling because I'm so full of bull, so full of crap. With condescending tribes making money selling lies. You might say everybody hates my guts. I'm offensive, I'm a bigot, I'm a fraud. Can you dig it? I'm a sexist, racist, homophobic, fat, pathetic putz. I'm a Nazi. That's right. I really am, because I'm a Nazi.
Okay, so, poor Rush is subjected to being called a Nazi, but using technology, right? Using technology that enables people to put together expression in a way nobody imagined the power before. And the question we should ask is, in this rip, mix, burn culture, what structure of regulation makes sense? Does it make sense that the burden of regulation that marks the old system of copyright should continue in a world enabled by this type of technology, in a world where a kind of democratic creativity, a much more diverse and widespread creativity, could enable an extraordinary range of people to participate in the acts of creative expression, using parts of the culture that they find around them and recombining them in ways that make a point. This is what free speech, a free culture, is about. And yet the system of regulation that marks our copyright law, system of regulation that insists that to do that creativity you need to clear permission from someone else, that system burdens our ability to create. So there's a documentary filmmaker, John Ells, who tells the story of a film he was developing for the San Francisco Opera. The documentary was a documentary of the Wagner Ring Cycle, and he wanted to focus on stagehands. So he filmed the stagehands playing checkers during the performance of one of the Wagner Ring operas. And in the background of the filming, there was a television. So it was a perfect mix. Here was Wagner, one floor up, checkers right in front of the stagehands, and a television in the background on which The Simpsons were playing. So after he took this shot and he edited the film down and saw that this was going to be a really beautiful ending to his film, he made the terrible mistake of deciding he should go ask permission before he released the film. But he knew Matt Groening. And Matt Groening, of course, as a friend, would give him permission to use this tiny 3.5-second snippet. So he called Matt and said, Matt, is it okay? Matt said, sure, call so-and-so. And so-and-so said, call so-and-so. And, when so-and-sos are being called, eventually it's a lawyer at the end. So eventually they got a lawyer at Fox Studios who owns the rights to this work. And that lawyer at Fox Studios said, sure, we'll license this 3.5-second, barely visible image on a television set in the background of your shot. It'll only cost you $10,000. And he said, $10,000? It's a documentary for public television. I don't have $10,000 to pay, my film director. How am I going to give you $10,000? She said, I don't care. I don't care what it's for. $10,000, you have to cut it out of your film. So in fact, he did have to cut it out of his film. And when he cut it out of his film, he was asked by many, including me, well, look, obviously this would have been fair use under copyright law. It would have been fair use to include these 3.5 seconds. You didn't need to get permission from Matt Groening or the owners of Groening's creativity. And Else revealed the thing that the lawyers of the world need to remember. There's a difference between what in theory is fair use, what you believe you could prove at the end of a $200,000 lawsuit before a federal judge, and what in reality functions as fair use. And the reality is that filmmakers and creators generally, if they want to produce creativity that's released to the world, must live by an extraordinarily strict set of rules, rules that say essentially you can create so long as you have the permission of the person whose creativity you build upon. And in this context, the question we should ask is whether that regulation makes sense where the opportunity is for this extraordinary ability to build on other people's creativity to be spread broadly, does it make sense that we have a regime that requires permission first? Now, the obvious response of the law here would be to recognize the changing technology and change the law in light of it. The obvious response would be to fit the law to a new technology in a way that makes sense of the tradition of the law. But our response is not this obvious response. Our response has been war. What Jack Valenti calls a terrorist war, where the terrorists are your children. This is a war being waged against those who use the technologies in ways which conflict with the regime set up in the 19th and 20th century. Now, part of that war has been waged against the pirates, who are taking commercial work and copying it and selling it. I don't mean the quote pirates, that's not the group I'm talking about. I mean real pirates, people who copy shop CDs and sell them on the streets. Those people are properly the target of prosecutorial power. But in addition to those people, the law has been deployed against people representing each of these other three categories. A company called MP3.com developed a technology to make it easy for you to listen to music you have purchased, both at work or at home, by letting you show the company the music you had, and then the company served that music to wherever you happen to be. It was not a technology that made it easier than it otherwise would have been to copy or steal work. It was a technology that gave you access to your work. But because in the process of building that technology, they had to copy 50,000 CDs to enable this technology to function, copyright law was invoked, no fair use defense was allowed, and a $120 million judgment was brought against the company, forcing the company into bankruptcy, or essentially bankruptcy, when they were purchased by one of the major 5 labels. And then that label, Vivendi Universal, turned around and sued the lawyers who had defended MP3.com for malpractice, claiming nobody could believe that it was legitimate for them to make this transformative use of creative materials. But the real message of the lawsuit was to say to lawyers in Silicon Valley, don't you dare support innovation which we, the dinosaurs from the last century, don't approve of. Negative Land is another company that set up this extraordinary collage using U2's music and Casey Kasem's unfortunate reference to U2 on his radio show, and was sued almost into oblivion. Then I described the fan fiction lawsuits that are being brought against people who simply engage in the act of retelling stories about the culture around them, finding themselves face down with high-priced lawyers demanding that they shut their sites down. And then, of course, as you all know, the RIAA has taken out its activities of suing 12-year-olds for the acts of sharing music online. This is a wide-scale war that is not attempting to adjust the law to the new technology, but is attempting to effect a land grab. A land grab in the sense that activity that was before free now becomes within the reach of the regulation of the law, and their aim is to use this opportunity to extend the control that these companies can exert. That opportunity has now been taken. The law has now been spread into a wide range of creative activity that before was unregulated. Regulation now is the norm in the context of the creative enterprises, increasing the concentration that these corporations exercise over the creative process, and increasing a certain protection which the law gives them to protect them from creativity they would not otherwise support. Why has this happened? We're taught in law school and in the rhetoric around intellectual property about the balance that intellectual property is supposed to strike. The balance between the incentives to creators and access to follow-on creators and to users or consumers of that creativity. The law is to strike a balance. But this balance is lost in our law right now. The law has become more and more extreme. There's a kind of IP McCarthyism that reigns in Washington right now, so that if you even question the extremism of intellectual property in Washington, you are labeled a red, which I have been labeled many times before. So the question is, where does this balance come from? From where does it come, or how do we support it or create it? And to see something of this, I think we have to look back. We have to look back to a different time. We have to look back to a different practice, to a different institution, a place within which this balance was struck by a different chairman running that institution. In 1992, this lecture series began, but it was launched by a Festschrift. My wife is German. I should say that better than I just did. Let's see. Festschrift. That's better, okay. Which celebrated the work of Congressman Kastenmeier, in particular with respect to his work in the context of intellectual property. That Festschrift to Chairman Kastenmeier described him as a quintessential listener to those who would testify before his committee about the balance copyright law should strike. It described a certain procedure that was established within that committee for evaluating the way in which copyright law would develop. A procedure that was supported through ex post negotiations by the chairman, who would sit down with people after the law had been drafted, people who came back and said, no, we need the law changed in the following 3 ways. And he would sit down with them and get them to settle their differences in a way which respected the balance the law had struck. This was a balance explicitly to be between the public and private interest respected in the law. A balance based on facts. He terrified one lobbyist who was pushing for the creation of a compulsory license for jukebox one day by turning to him as he was testifying and saying, well, what are the economic consequences of your particular proposal? Which, of course, facts was not something the lobbyist was really very eager to talk about, so he walked out and said he would have to come back with the economic consequences later. But this marked a character for the process that said facts would guide us in determining this political and economic balance of regulation. And a certain humility marked this institution. And my favorite example is the example relating to the 10 extensions of copyright that happened over 15 years between 1962 and 1976. In 1962, Congress expected that it was going to re-author the copyright statute, updating it into a statute more technically aware of the existing copyright and technical rules. The last statute was passed in 1909. It was time for a change. So in 1962, Congress extended the term of existing copyrights that were going to expire in 1962 for 3 years. Then in 1965, Congress did it again. And in 1966, Congress did it again. 1967, Congress did it again. And in 1967, Congressman Dingell, not happy about this pattern of extension, said this on the floor: "There is no justification for this. This is the sheerest kind of special interest legislation." And in an extraordinary speech, he attacked this in a vicious and harsh way. We are conferring additional rights, Dingell said, not contemplated by the law, nor sanctioned by practice, and not required by any reasonable protection of legitimate interests of those persons who are holders of copyright. Congressman Kastenmeier disagreed. He said, "Mr. Speaker, the House has already spoken many times on the question that the gentleman from Michigan has raised. The House has decided that existing copyrights should be continued while the Congress was in the process of general revision." So in 1968, practice was continued again. The term was extended. 1969, the term was extended again. Dingell again came to the floor. "I would ask the gentleman," he's asking of Congressman Kastenmeier, how many more times are we going to find the House extending copyrights and preventing work from properly going into the public domain as the framers of copyright law intended? Congressman Kastenmeier responded, I would say that the Librarian of Congress in his report to the House, quote, says, it is important that this fifth interim extension of subsisting copyright be the last of the series. And Congressman Kastenmeier promised, I can say personally, and I think I speak for the members of my subcommittee, that we expect this to be the last. I do not expect to again come back and ask for another one of these extensions. Well, whether he came back or not, in 1970, there was another extension. 1971, there was another extension. In 1972, there was another extension. Congressman Dingell, no longer eager to maintain the decorum of the floor of the House, the fact of the matter is this bill stinks, and he goes on in even stronger rhetoric. This does nothing but to put it to the people at large. Put it to the people at large was a great 1970s phrase. Everybody knew what those copyrights did when they got them, and everybody knew what they did when they inherited them or bought them. But here is the Congress of the United States extending them again at the expense of the public. And here's the humility of recognition in the face of facts and practice, Congressman Kastenmeier. We got into this situation 10 years ago, in 1962, when we granted a 3-year extension of subsisting copyrights because in the warm glow of anticipation of copyright revision, we thought it was the equitable thing to do. I believe we have long since concluded we were wrong. Then some of us on this subcommittee promised our colleagues we could not come back any longer asking for these annual extensions. So in 1969, I said it would be the last time, yet here we are again tonight doing the same, I regret to say. We should allow them, the copyrights, to die, as they were intended to die in the year 1909. At that time, we told the author he would have 56 years and not a day more. We are asked to breathe life into something which has expired, which is dead or should have died. We are asked to extend the life of a copyright obtained 56 years ago under the law as it then extended. Then in 1974, again Congress extended the term of copyrights. Congressman Kastenmeier, I cannot concur in the action of my colleagues in ordering a further extension of expiring renewal terms of copyright. I continue to be of the opinion that in too many instances, the measure will operate to provide an unjustifiable windfall at the expense of the public domain. Congressman Dingell had a crisper way of putting the point. Mr. Speaker, they are going to figure out how to extort further from the reading public, the listening public, and the consuming public. And indeed, that's in fact what they did. For 19 years later, after the 76 Act, which extended terms of existing copyrights by a maximum of 19 years, we got to 1995. 1995, they came back, and they asked for another extension, the 20-year extension, which became the Sonny Bono Copyright Term Extension Act in 1998. When that bill was introduced, it proposed a 95-year term for corporate works and life plus 70 for works of authors. Mary Bono, the wife of Sonny Bono, who had since died, said Sonny wanted the term of copyright protection to last forever. I am informed by staff, she says, that such a change would violate the Constitution. But as you know, there is a proposal by Jack Valenti for a term to last forever, less a day. Perhaps the committee might look at that in the next Congress. And Bob Dylan, just to give you a sense of how crazy DC can be, Bob Dylan came to testify about this extension. And Bob Dylan said that when he created some of his greatest work, he thought the term of copyright was life plus 70 already, suggesting that if it had not been life plus 70, Bob Dylan would not have composed his work. Now, the congressmen listened to this and shook their head in all seriousness because that was the level of insanity that had consumed the committee by this time, that this extremism could be taken with a straight face. Something was lost in the 15 years since. A practice of balance was lost. Even the memory of balance. The memory that the job of copyright law is not simply to serve the interests of the heirs and assignees, but also the public. And more importantly, the institution which sustained this balance. The institution which saw it as a matter of ethics, and most important to me, a profession that saw it as a matter of ethics. And I mean by that the legal profession, that saw it as a matter of ethics that the law would balance these two extremes. Because the single most striking fact about this debate within the law right now is that it is dominated within the practice by one side of the debate, by a side of the debate which works for clients, and by an ethic which now says the job of the lawyer is to answer only the interests of his client, which means that the strongest, most powerful lawyers in this debate are those that do nothing but puppet the image their client would have them speak. Which means when people stand up and remind the world of a different view, a view that says this is to strike a balance, not to simply do what the most powerful say, they are not just disagreed with, they are ridiculed, as if there is no space in the law anymore for those who would insist on something other than the most extreme position. And this, in particular, gets perverted by another problem which the congressman remarked upon when he still served in Congress, the practice of law professors in particular to become the tools of exactly these same interests by selling their services and their opinion in the course of giving evidence and expert testimony in the context of these matters. A profession, both the lawyers and the law professors, who have lost the idea that the job of the lawyer is not simply to speak for one side, but to sustain the dialogue that exists between two sides by continuing to support both, especially in the face of the strength of one. That tradition has been lost. This institution, this attitude, this integrity, and this leadership has been lost. Now, it's been 13 years since Congressman Kastenmeier left his post. Both before that time and since, there has been a massive concentration in the interests who are most directly affected by copyright legislation. Today, more than 80% of the music distributed in the world is distributed by 5 companies. 70% of the radio market in the United States is owned by 4 firms. 80% of cable and television is controlled by just 6 firms. In 1947, 80% of newspapers were independently owned. Today, that number is significantly below 20%. In the 1970s, 10% of first-run films were foreign films. Today, that number is below 0.5%. There's been a massive change in the way this market is constructed and the way it serves, and a massive increase in the set of rights which the law grants these copyright owners, and the war representing massive litigation enforcing these rights against copyright users. The aim of this combination is to reestablish a certain amount of control. We come from a tradition of free culture where an important role for copyright is balanced by limitations in copyright. We become a permission culture where the ability of creators to build on their past is increasingly a function of the permissions they can secure. This happens without resistance, at least without congressional resistance. It happens without balance being a term used in the debate by those who seriously intend the word to have any real meaning, by either Congress or the court. This balance is forgotten in the current debate, and this loss is an extraordinary loss to the opportunity of this culture to flourish. Now, I have a special affinity for Madison. It was Congressman Kastenmeier from Madison who brought my uncle to Washington to work on the impeachment of Richard Nixon. It was when my uncle came back and he stopped in my hometown and explained to me what a lawyer was, that I was convinced I would become a lawyer. My uncle said to me in explaining this extraordinary event of the president of the most powerful country in the world stepping aside because of arguments made against him, that the law was about the process by which reason constrained power. That process is the process that the namesake of this town envisioned for our government, James Madison. It was James Madison's vision of the role of a Congress, that the Congress would serve as an institution that understood the dual loyalties in any particular issue and sustained an institutional structure that would defend that mature process of decision-making. It was a Congress that could do that. Now, when I took the challenge to the Sonny Bono Copyright Term Extension Act to the Supreme Court and lost, decisively lost, wasn't even close, hammered by the Supreme Court, two wonderful opinions, but dissenting opinions by Breyer and Stevens notwithstanding, the most depressing moment in that process was the remedy that the court suggested. The remedy the court suggested was Congress. The remedy was, go back to Congress and let Congress properly strike this battle. And the reality was, my career had begun after Kastenmeier's career had ended. And in my view, Congress was nothing more than the most susceptible special interest lobbying group there could be. How could you possibly look to that group as the place where this balance must be struck? But the truth is that in preparing for the honor of being able to give this lecture, the single most important lesson I draw is the contingent hope that this structure of an institution that maintains balance can exist in that institution called Congress. This contingent hope that there is one or two important leaders in that institution that can speak for something more than the high-priced lawyers who sit in their offices. That hope was a reality for at least 20 years, and I think many more in Congress, in attempting to sustain a balance that this structure of government, given to us in design by Madison, depends upon. We have forgotten that now. But our forgetting it now is a reason to teach our students about it again. Because that possibility is not just the reality that existed before, but an essential part of who we must be if our country is to sustain the promise of free culture that is our past. Thank you very much. If you want to turn the lights up a bit, I'm happy to take some questions.
Your point about balance is powerfully compelling. I found myself noting one point you raised concerning the non-commercial copy casualty being the 12-year-old. And I can sympathize with the 12-year-old, but I'm wondering, when the 12-year-old and a million of his friends share millions of copies of works, what happens to the needs of the rights of the artists and the royalty owners? I don't have a solution or an understanding of this, but I have a difficulty denying them the rights that are generally accorded. What do you have to say with this?
So there's no doubt that under, in my view, under current law, behavior file sharing is illegal. It's it is, are we there now? Yeah, we're there. Okay. It's illegal. It's illegal in the sense that it is an improper copy made of copyrighted work without the permission of the copyright owner. But the question we should ask is, does the law make sense? Does it make sense to assure artists get paid? Does it make sense against the background of this technology to assure that artists get paid? Now, the standard response of the industry has been, it's illegal, and let's launch a war of prohibition against all those who engage in this behavior, which, according to some counts, includes 60 million Americans. Right? Now, you might look back on the history of wars of prohibition and think this never works. It's a bad idea to launch wars of prohibition against your own people. And that should lead you to ask the question, is there another way to assure that artists get paid for the content which they produce? Now, the history of copyright law is filled with examples of what the lawyers unhelpfully call compulsory licenses that have been proposed in this context to make it so that businesses that enable the file sharing of content would in some sense be responsible for the content that's shared, and artists whose content is shared would get paid as a function of the frequency with which their content was consumed. So it becomes almost like an ASCAP BMI model, but attached to the peer-to-peer system by law generally. Now, I'm not sure if that particular solution is the best one or what the mix of incentives and structures is, but I am pretty sure that what we ought to be thinking of is the system which imposes the minimum burden on the opportunity for this network to facilitate creation and sharing of content while assuring that artists get paid. And the alternative system, where we attack 12-year-olds or attack students who set up search engines in their universities, is not a system which is any good at making sure artists get paid. It's not like the existing recording industry is an industry which is making a lot of happy musicians out there. I mean, there are 10, right? Britney Spears is one, Madonna is another. But beyond that 10, it's not like, artists are out there rolling in the money, and that's because the structure of distribution set up by this system for the technologies of the 19th and 20th century is not one which returns lots of revenue back to the artists. Now, I think we could have a different system for distribution. Content would be cheaper, artists would get more money, and there would be more music consumed. And that's where we should be focusing rather than waging this war against file sharing. Yeah.
Hi, I'd like to preface my question by saying I'm not a lawyer and I'm not a law student. So I have a question about term extensions and the unexploited works, the problem of unexploited works not going into public domain. Hasn't anyone suggested the baby step solution of putting back in place term extension requests such that, Mickey Mouse, Disney can keep putting in extension requests, but all that stuff out there that no one cares about could drift into the public domain?
Yeah, in fact, I've taken that baby step. We've proposed a bill. After we lost in the Eldred case, we proposed a bill that basically would say 50 years after your work is published, you've got to pay $1 to the Copyright Office and register the work. And if you register the work, you get the benefit of whatever term Congress gives you. And if you don't, the work passes into the public domain. And we know from historical estimates, 95 to 98% of the work would pass into the public domain. And for that work which continues, you'd at least have a simple place to go to know from whom you want to license the work. Right? So it's the sort of solution which people, ordinary people who live outside of the Beltway, listen to and say, yeah, of course, this is completely sensible. And Congresswoman Zoe Lofgren, a Democrat, and Congressman Doolittle, a Republican from California, co-sponsored and introduced the bill. And there was a massive online campaign to get that to happen, and that was very exciting. But since then, the Motion Picture Association has launched a counterattack. They will not permit this to happen. And of course, they have more power in Washington than baby step people like I do, right? So they've gone around to all of these Congress people and started raising all sorts of nightmare scenarios about what would in fact happen if this occurs. And so now it's a political battle, right? And the political battle is about whether we can crack through the effect of this lobbying effort to get to something that would be fairly sensible and obvious. And I don't know, my brand is typically pessimism, right? And my publisher says stay on brand, so I don't want to be too optimistic about this. But it is an idea that seems to strike people as right, easier than file sharing or the Napster case. This one seems like obviously, right?
administration wouldn't really care all that much about? And what are their arguments in support of their claims?
Well, I can, if you email me, I'll email you their memo. It's so embarrassing, I'm embarrassed to try to repeat the arguments. You'll think that can't possibly be true that they would say this. But they say things like, well, Congress already decided that registration was not appropriate in the context of copyrights. Well, when Congress decided this, it was before the internet. It was before the opportunity for millions of people to recreate and use the internet to spread. So it might have been right in 1976. I don't know. It's a European idea, so I'm skeptical. But still, 1976, it might have been a good idea. But I don't think that should preclude us from reconsidering it today. That's one of their arguments. The second argument, this is my favorite, it would burden poor copyright owners. Right? So it's the granddaughter or grandson barely making it on the copyrights grandfather, and that person would have to send in the dollar, and that's a lot. So and then they say, well, and it would be a terrible burden to have to set up a system of registration. And the answer to that is, well, maybe if the government does it, it would be a terrible burden. But we could imagine privatizing that. And if we did privatize that, the point is that might be a burden, but the burden imposed on other creators who want to track down this creative work is far greater than the burden you impose on the creators to claim their additional term. But I think the real thing that's scaring them is the slippery slope, right? Boy, if Congress starts thinking reasonably about copyrights, and they say, 50 years, then somebody will say, well, why isn't it 20 years? Who needs more than 20 years, right? So this process would lead back into a position where you would have something rational, and I think they just don't want to take the first step. They want to signal any victory by the side which, before I think had a role in copyright law and doesn't have that role anymore.
You've given us an argument that's essentially about structural imperfections in Congress, and this is certainly not the only place where those happen. And what I'd like you to talk a little bit more about is the court's response to those structural failures, because I'm sure you raised them in the court. For those of us who don't follow copyright, I'd be curious as to why those, the judiciary, which is sort of the epitome of the legal profession, is not following this rule of balance, particularly where this kind of structural failure is entrenched. One of the reasons Jack Valenti has so much power is because, of course, newspapers and media are how congressmen and senators perform for real election.
Right. I don't know. It's like I grew up a Republican, but when Dick was talking about me coming to understand my values, what he was really saying is then I became a Democrat. But I clerked in the Supreme Court for Justice Scalia, and I naively really expected that we would make this argument in the Eldred case directly, squarely at the conservatives. And our argument was originalism, limits on Congress's power. This is what defines you as a movement, originalism and limits on Congress's power. And if you say that Congress can't be trusted with the commerce power, right? Well, here's a much more obvious example of where Congress can't be trusted, and it's a very simple way for you to solve the problem, the incentive problem, which is to simply say you can't extend an existing copyright. Right? If they couldn't extend an existing copyright, no lobbyist would come to Washington and say, please extend future copyrights, right? Because the value of $1 100 years from now is literally almost nothing, right? So nobody would ever push for an extension again if the court had simply said that. Well, we made that argument, and the government's response was, well, Congress has been doing this forever, right? And, 10 extensions in 15 years was pretty good evidence that Congress has been doing it forever. Congress has been doing this forever. Nobody has ever questioned it before. And so, therefore, you should just let Congress continue to do it. And, when we first heard that argument in response, we thought, this is crazy. The court will never take that seriously. But in fact, what happened was, we had this extraordinary collection of people on our side from all over the political spectrum. The Cato Institute. Phyllis Schlafly was on our side. Milton Friedman, Ronald Coase, James Buchanan was on our side. And then we had the Free Software Foundation, and we had leftist law professors and progressive law professors. And then we had Intel filed a brief on our side. So we had a great collection of people on our side. On their side were all the media companies in the world. Right? Time Warner, Disney didn't file a brief, but that's because Disney's what created that statute. They've gotten enough grief from it already. So all the industry in the world, and I think what the courts looked at it was a bunch of crazies versus mainstream America. And how are we going to possibly question what mainstream America is asking us to do? And so they wouldn't do it. Now the most frustrating part, I said, was that they wanted to trust Congress. But from the standpoint of a lawyer, the most frustrating part was we made our case based on what the language of the Constitution is. Right? Congress has the power to promote the progress of science. And we made a very elaborate argument on the basis of historical understanding of that language. Justice Ginsburg's opinion nowhere attempts to explain what the Constitution means when it says Congress has power to promote the progress of science. Her opinion basically says Congress has done it before, no reason not to let Congress do it now. That's all it does. So, I feel in some sense like the last naive law professor because everybody said, oh, come on. I remember I presented this argument in Texas. Sandy Levinson, who's a good friend and a kind of crit law professor, said to me, you're absolutely right. I'm absolutely convinced. And then he said, but when is the last time reason won out over all the money in the world? And I kind of thought back, the civil rights cases they were just against a bunch of bigots. It wasn't all the money in the world on the other side there. When was the last time that reason won out over all the money in the world? And, I said, Sandy, that is the most boring way in the world to think about the law or constitutional interpretation. I reject that way of thinking about the law. And he kind of smiled at me and he said, okay, fine. And then he sent me a note afterwards. He said, when is the next time that reason will win over all the money in the world? Yeah.
One other, I guess the part that I've never understood is on the music piece. Wouldn't good, rational economic actors, like the corporations, look at that, see an expanded market, and create some market like you're starting to see now with iTunes and others whereby they license it? What's taken them so long to get to that? Just that they had the congressional chit in their pocket and didn't have to? Or any thoughts on why the market didn't fix it?
There's no doubt that the market as a whole would be better off. Consumers would be better off, artists would be better off, there'd be more technology sold, everybody would be better off. But I think there's no doubt that the 5 major labels would be worse off. Right? They make their money on the basis of the ability to control distribution. And what we're talking about is a world where the ability to control distribution disappears. So I think they're rational to fight like hell to stop this new technology. Right? And what's striking to me is this is really, I think, the first time in American history where the law has been effectively used to stop a transformation in the context of copyright. Right? Historically, if you look, I think one of the most important first instances was when they came along, they developed the player piano or the records, right? And went to the Supreme Court, the composers went to the Supreme Court and said, stop the Napsterization of our content, right? Because basically these record companies are recording our music and then selling it to other people and not giving us a dime. Same thing with player pianos. They're recording our music, selling it, not giving us a dime, and this is theft. Stop it. The Supreme Court said, not theft. Not theft under the Copyright Act. We won't have anything to do with it. Go back to Congress. And Congress came along and eventually created a compulsory license, which gave the recording companies something they wanted, but gave the authors something they wanted. Same thing happened with cable television. Cable television twice went to the Supreme Court. Twice said to the Supreme Court, stop the Napsterization of our content, because cable companies were stealing broadcast and rebroadcasting it to their customers. They were charging their customers for that content, but they weren't paying any of the money back to the original broadcasters. Twice the Supreme Court said, not our problem. So it took Congress, this time, almost 20 years to get around to striking the balance. That was the 76 Act that Congressman Kastenmeier helped shepherd through. And in each of these contexts, I think the message is that the technology goes first and the law comes in and balances it afterwards. And that message was most clearly what the Supreme Court said in the context of the VCR, right? VCR was a case where Jack Valenti went around the world talking about the Napsterization of film content. Here was the Boston Strangler of the American film industry, as he called it. Worse, it was a Japanese Boston Strangler of the American film industry. It was stealing profits from American filmmakers because people were recording shows off of their television set, and Sony had designed the system to make it possible for them to record shows off their television set. So they intentionally made it so that these people could steal their content. And the Supreme Court said, look, when a new technology changes the way content gets distributed, it's not our job, the Supreme Court's job, or courts in general, to rebalance the interests between copyright owners and the public. We ask a very simple test. Is the technology capable of a substantial, non-infringing use? Is it capable of that? Not is it capable of that? And if it is, then we're finished. It's not our job anymore. If it's capable of a substantial, non-infringing use, then the matter is for Congress to resolve. And Congress then took up the question of whether they should create some kind of licensing structure to deal with VCRs, and they eventually said no, the film industry is getting enough money as it is. Now the point in all of those cases was the technology was allowed to develop, and then the law came in and regulated it. With the internet, that's been inverted. With the internet, courts and Congress have marched in to stop the evolution of new technology in order to defend the old method of distribution. And so in Silicon Valley now, nobody will invest any money in a technology to deploy content in a way that the RIAA or the music industry won't sign off on. So, I think Steve Jobs at Apple is doing an amazing job. But again, I'm not sure that a model that depends upon controlling the distribution of content really is the most efficient model for making sure artists get paid or making it so that the internet develops. There's another way. And if we adopted that other way, I think we would have much greater growth, much more money for the artists, and it might be that the recording industry, recording labels collapse, but wouldn't be the worst thing in the world if the proven monopolists collapsed. Yeah.
Is anything different going on in Europe?
No. Unfortunately, Europe is weird. Europeans are typically pretty good at thinking about the balance in property rights. So they think Americans are silly because of our obsession with property rights when it's about real property. But the Europeans are even more obsessed about property rights when it comes to intellectual property. Right? They have a very different tradition. Now, in some ways, I think it's a good thing because that typically manifests itself in a way that supports authors more than publishers. So authors have real power in Europe against publishers. And in the United States, authors can basically sign all their rights away to publishers. So that part of it is good. But it's weakened the opportunity for Europeans to think creatively about how to create more of a balance in this context. So they certainly are not going to push for registration. They're certainly not going to push for limits on the term of copyright. And they've been very eager to follow the United States in imposing these technical mandates through statutes like the Digital Millennium Copyright Act. Now, you would think countries like developing nations would be the perfect place, especially if they knew anything about American history, because America, for the first 100 years of our republic, didn't respect foreign copyrights at all. Until 1891, we were a pirate nation, right? So you would think the Asians would say, well, come on, give us at least 10 years where we're allowed to, take advantage of whatever intellectual property the world produces because we're poor. And when you were poor, you did it. You did it for 100 years. But they've been cowed into extremism on the intellectual property front because the United States enters into bilateral negotiations and says to all of these nations, unless you respect intellectual property rights strongly, none of your goods can come into the United States. So, we have a very good strategy for forcing this IP extremism on anybody around the world. So I don't really know yet who the great hope is. I mean, Afghanistan had a really great copyright law. It was just 20 years, but I'm not expecting they're going to do much to foment the revolution. Yeah.
Thank you. Yesterday afternoon, I looked out my office window and noticed leaves all over the place. And as I do every fall, I thought of Robert Frost's poem, Gathering Leaves.
Don't repeat it right now.
I won't. And I did a little searching on the internet and realized it was published in 1923 and that its term will now expire 70 years after he died. That is in 2033, and probably after almost everybody in this room has died. And I thought, wait a second. The term of copyright is not at all limited like the framers believe. And then I wondered about the Eldred case. If I recall correctly, the direct question whether 70 years plus the life of the author is a limited term within the meaning of the Constitution was not in that case.
That's right.
And I wonder if it had been in that case, if the case might have been decided differently.
Right. It's very careful reading, that's right. Because we explicitly decided we would not frame the question around the issue whether 70 years is too long and 50 years is not too long. And the reason was we were afraid of the court saying, well, how are we going to tell the difference between life plus 70 and life plus 50? What is the difference really? Right? So if you say life plus 70 is too long, but life plus 50 is not too long, what's the line between those two things? So what we said was, okay, fine. You understand that there's a problem here about copyright terms extending. Here's a simple rule. Just tell Congress they can't extend an existing term. Now, we explicitly, though, I mean, we were going to put that claim in the case, too, as a second claim. But the strategy was to reserve it, because what it did was let the government argue, as they repeatedly did all the way up to the Supreme Court, of course there is a term that is so long as to be effectively perpetual. We concede 500 years would be too long. But we don't think this term is too long. So that means that from the standpoint of the government's view, limited times is not technically limited times. It's limited times that's appropriately short in light of what the framers would have thought. Now, what happened in the case is that Breyer has this wonderful opinion that basically shows that there's no difference between life plus 500 and life plus 50. They're both effectively perpetual. Right? So now the premise is out there for us to argue, as we are in two other cases that are working themselves. Well, one's been filed in Denver and the other is about to be filed in California, working their way up to raise exactly this claim. Now, you know, my real hope is that to the extent this claim becomes sustained and there are cases out there that push it, Congress will be driven to do something reasonable here. I'm not sure the Supreme Court, even though the way we framed it, they wouldn't have to overrule Eldred. They would just have to decide it on the different grounds. I'm not sure the Supreme Court would go our way, and you know, maybe if the court changed, I don't know. But so we're pursuing it like that. But if we get to the Supreme Court, the essence of the argument will be, it's not just that it's life plus 70. It's also that they took the renewal requirement out. So what happens is the average term goes from 30 years to 95 years in just 30 years. It's tripled. Right? It's been a radical increase in the copyright term, the effective copyright term. Now, in the old case, the government pointed to tradition. But we can point to tradition in this case and say the tradition is on our side. The tradition is we've always had a renewal requirement. And if you're going to remove the renewal requirement, then you've really got to be worried about how long the term is. And we know that the term is so long now as to be effectively perpetual. I mean, we argued that the term was 99.8% of a perpetual term. Justice Breyer chided us in his dissent. He said it's not 99.8% of a perpetual term. It's 99.99997% of a perpetual term. All right, you know, whatever.
I think we're going to thank Professor Lessig at this point for...
Thank you very much. Thank you.
Wonderful remarks. Thank you.
Thank
and please come back and join us again. To encourage you to do that, this is the symbol of the law school, the gargoyle. And I've never done this before, but your remarks prompt me to say you certainly have our permission to copy it and transform it if you want. And we'll take care of shipping it out to you.
Great.
So you don't have to
Thank
get
you
it on,
very
take it on
much.
the plane. Thank you. Everybody is certainly invited to stay with us for the reception, which will be outside in the atrium and start imminently.
There's a reception. Totally going home. It's better in there every time I turn.
disappeared very quickly.